Welcome to Women Winning Divorce with your host, Heather Quick. Heather brings over 20 years of law experience that advocates and empowers women to achieve happier and healthier lives. Each week, we provide knowledge and guidance on different aspects of family law to help lead women through the difficult and emotional legal challenges that they are facing. Listen in as she discusses issues including divorce, custody, alimony, paternity, narcissism, mediation, and other family law issues to provide insight on the journey of women winning divorce. Welcome to the show. I'm Julie Morgan, and I'm joined by your host, Heather Quick. How you doing, Heather?
I am great. How are you today, Julie?
I'm doing very well. You know, I need to think of a different way to say hello to you because I realize, hey, you say that the same way every single time. Like, I don't even know what's happening. I don't know.
We just get in a groove. So I'll help. I'll think of some things. How about that? I'll see if I can change it up for the next show.
Exactly. Yeah, I know. I need to change it up. I do. So today's show is about enforcement orders. Okay, first of all, let's define that. What is an enforcement order?
So if you think of enforcement like law enforcement, it means holding somebody really accountable to a court order. So when this whole topic is really about how do you make somebody do what was agreed upon in an order or what was, either way, even whether it was agreed upon or not, eventually it was ordered by the judge. And that's why it's so important to have things put into an order, because now a judge has ordered you to do this. If you don't, that is our remedy. Go to court and say they didn't do this, judge, make them do it, whatever it may be, which we'll get into.
Okay, got it. That makes sense when you break it down and think about law enforcement. All righty. So in terms of course, family law, after a divorce is final and everything has been decided upon, what happens if one parent does not follow what was agreed upon?
Well, and therein lies what we're talking about today, because many times it's difficult and time consuming to enforce the order that is in place. And that is generally the remedy that you have, which is you got to go back to court. Nobody, that's not the ideal answer. Obviously, somebody's like, well, make him do it. That's the only way that we can is, going to court. And very often it needs to be something worth doing. And we'll get into that as we talk about the different things. Maybe they're supposed to always be there at the exchange at 5 p.m. and they're always late. All right, that's not worth going to court because that's going to be time consuming money. And for that one thing, probably you're going to have to let that go or try to work through it. So, but when it's money or a substantial amount of time or things that, they're not doing or not things that they were supposed to do as a result of the divorce, and they're not, we usually have to, there's not going to be another remedy.
Okay. So it needs to be, worth the time.
It does. And I would say that that's something obviously we talk through with clients, because then you do have to weigh it and, weigh, okay, hey, what is it they're supposed to do? And what's the likelihood of our success? That really mostly only an attorney can tell you, for the cost that will be involved in doing it. So, we really have to evaluate all of those things to determine it. And many times, my philosophy is, hey, if we determine that there is enough, well, now let's look at everything within the document, because if we're going to court, we're going to court. So now let's see all the other areas where maybe you wouldn't have individually picked those. But if they're not in compliance with one thing, there's usually multiple things they're not in compliance with.
So you're really getting your money's worth.
Yes.
Okay, that makes sense. So what are the steps? Like, what is the process? Do you just say, okay, judge, I need to talk to you? Like, what are the process? I know that's not the way you do it, but what's the process of it?
So the process begins with, obviously, say, okay, you've evaluated, you've talked to the lawyer, and you guys have decided, hey, we need to file something. because that's how we begin everything, is filing something in court. That's the way that we communicate with the judge, is in a written motion. I know, just like you said, you're like, can we just call up the judge, send an email? No, it's much more formal than that. That is how we communicate in drafting a motion. So we would draft, say, a motion for contempt or a motion to enforce an order. It just, the language, and depends on how things are ordered, those are pretty much interchangeable. We file it. Now, sometimes, depending on what it is, they might need to be officially served. Some things can be sent by mail. We usually serve it, because what you're wanting in contempt and enforcement is things to be done as quickly as possible, which, as we know, through doing the show with me for so long, like, that's not always a guarantee. So we want to look at, hey, what are ways to streamline it? Well, if we have proof of service, they can't say, oh, I didn't get the mail, or, another delay. So you serve them and you set a hearing. And if ideally it's just on that issue, then that, moves forward in front of the judge. And then they have to tell the judge why they didn't comply.
Ah, okay. Are there certain, I guess, things associated with the divorce decree that usually fall into one of these two categories of contempt or enforcement?
Usually you're going to see alimony and child support. Like, those are going to be, I would say, the number one issues, because it's financial. There could be some, time sharing, custody things, but I would say the most common are going to be financially related.
Okay. And to break it down, would that fall under the contempt order?
Yes, because what you hear is, hey, you're in contempt of court. You haven't done what the judge ordered you to do, which is ordered to pay a certain amount to exchange the children. Maybe you have not given them back. Maybe you're not paying as much as you're supposed to, things like that.
Okay, well, what would be the opposite? That's just a random thought. What if someone wants to change, let's say, how much alimony is, or child support payments? What would be the opposite of this? It wouldn't be contempt, right?
That's correct. They would file a modification to change it. And what and that kind of protects them sometimes. The date they filed the modification, they filed with the court, hey, I lost my job, I have more expenses, I can't pay this. So that amount of money that if they're paying less, it may or may not, they may not have that accrued against them, if that makes sense.
It does. So this could be their way of stopping a contempt order.
Yes, and it usually is, or it's in response many times to a contempt motion. They will file a modification, which then creates a much bigger, it turns it into definitely a bigger proceeding.
Okay. So if it's not financial obligations or custody issues, what about for property? What does that fall under?
So that is going to be enforcement, and not everything is, you can't. So a lot of times, let's say a property has to be sold and divided as a result of a divorce. Um, then what, that's not contempt when they don't do it necessarily. That does have to go into enforcement, and that's, a lot of procedural issues we won't talk about here. But what's important to know is that your attorney advises you of whether or not this is something you can do by contempt or not.
Okay. All right. So your attorney really is going to break this down. Okay. This is how this works, and that works. Really, just like everything else we've talked about, it's up to your attorney to explain it all.
Yes.
All right. Yeah, because I mean, I wouldn't know anything. I'm thinking it's all contempt, because when I saw enforcement, I said, "What's that?" Okay.
And right. And it can, that's where, some people say, well, we've agreed to everything and we're going to do our own divorce. And when you have property or children, this stuff matters. And so let's say, the house is to be refinanced in 6 months, and if not, it gets sold. You need to really specifically handle that language in that divorce to make sure you have the easiest way possible to enforce that.
Yeah, because they could not do it. And if you didn't have the proper language, then it's okay that they didn't do it.
Well, yeah, I mean, it's just going to be so much harder to make them do it, and that's not what you want. You've already been through the whole process, and now you're like, "Oh my gosh, I've got to deal with even more stuff."
Now, when we think about a contempt order, where does the burden of proof lie?
So, the person seeking the contempt has the burden of proof. Meaning you're the one who's got to prove that, your spouse, your ex-spouse willfully disregarded the order, meaning they, obviously knew there was an order and they are intentionally not doing it.
But isn't it very difficult to prove intention?
It is. And so where that comes down to is that it, if we're talking about money, they have to have the ability to pay, and they didn't. And that's where it can get really tricky.
Okay. Because you would have to prove that they have the ability to pay.
Correct. And you don't always know that.
Even after they filed the financial affidavit during the divorce?
Well, things have changed, but yes, you do absolutely look to that. Um but you don't know usually. Like, what if they lost their job or whatever? And generally speaking, that's part of the pre-filing investigation. And not that that's an in-depth, like, private investigation. I'm not talking like that, but you need to know. Like, I mean, I tell people, like, hey, we got to do a cost benefit analysis. Like, if your ex is completely broke and homeless, we can go get an order, but it's only as valuable as the paper that it's on. So that's important to consider.
Okay, so basically that's where you guys really do your homework. But tell me this, do you ask the client to do their homework before they come to you?
But usually they do, and if they've called in, because sometimes they'll be like, "Well, why now? Like, why are you doing it now?" And they're like, "Well, I think they're about to come into some money." That kind of thing, or it looks like they're selling their house, so now we might have a reason with which, or an ability to recover the money. Because that's, to me, that's really important. I mean, yes, we can go to court um on all of it, but we're wanting um I want results for our clients. I guess that's the best way. And so what are results? The money, the ability to pay. Plus, you're going to always ask for your attorney's fees to be repaid because you had to go to court just to make them do what they have been ordered to do. So we look at all of that, because if you end up at the end of the day, yay, you won in court, you got an order, he's got to pay this, but he's got no money with which to go after it, there's a feeling of there's going to be a letdown for the client. And, there's not what you would call like a debtor's prison. It's not like the judge is going to put him in jail. Now, sometimes, yes, but generally, no. And again, that doesn't get you any money. Now, it may make you feel better about the whole thing, but
Yeah. But for how long would you feel better? You know what I mean?
I don't know. I think you feel good for a pretty good time. But again, the only way someone, like, and this is way back in the day, and I'm sure they still do this. There's like, there are hearing officers for child support court, and some people show up and they've got, a lot of jewelry on, And I've had judges say, all right, well, you better take that jewelry and sell it, because you're going to a holding cell and your bail is going to be the amount that you owe. And that tends to be more for child support. It's going to be harder to get that with alimony, but not impossible. I've certainly been able to achieve that. But they gotta have the money or access to it if jail is going to be an appropriate, because the whole thing is, it's not supposed to be as a punishment. It's supposed to be as, enticing them, persuading them, well, you will get out of jail if you pay the amount you owe.
That makes sense. But it seems like um, it could work as a punishment as well as an
Yeah, I mean, yeah, jail is definitely a punishment. And it is, yeah, you're going to jail because I've told you what to do. And usually that's not going to happen on the first time. I don't want anybody listening thinking, oh, yeah, we'll go to court. He disobeys, he'll go to jail. It takes time. It does. So it's certainly not something that happens on the first time.
And would jail be extreme?
Yes, indeed. Indeed, it would. And appropriate in many instances, but it's totally going to be extreme. And it's usually listed, like when you file a contempt, you list that's what you're asking the judge to do, because they have to be on notice. That's just part of due process.
Okay. Now, we don't have time to talk about that in this segment, but I want to get back to that. You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. When we return, we're going to talk more about these enforcement orders, custody, child support, and alimony. Stay with us. Welcome back to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. Heather, when we went to break that after the first segment, one of the things that you said was about you had to let them know that jail is a possibility. I thought that would be something that you kind of ease in there.
Well, yeah, it's just, again, without getting like too deep into the weeds and stuff, it's really just putting somebody on notice. When you file a hearing and you're asking the court for something, the way that the law works is, hey, you better let them know ahead of time, hey, these are the things we're asking for. And if you don't appear, or you could be found, to be put in jail, you could be incarcerated as a punishment. Now, and the reason I think that it is important is because when we do family law, it's civil law. So it's not criminal court. So if you're seeking something that's a little bit more like criminal, there's got to be a little bit of notice on that.
Okay. All righty. I was thinking you could show up and say, yes, this is what I want. But that's not the case.
Correct.
All righty. So let's talk about custody, child support, and alimony. Of course, that falls under contempt order. So if granted by the judge, there are different ways the court can ensure payment. How can they do that to make sure I get my money?
So there's a lot of different ways, and this is part of, being creative from the legal side. Because, okay, the one way we think of is garnish wages. So yes, that is absolutely a remedy. Now, many times the court can suspend the driver's license. And, that's like a whole nother, that's another issue, because that people drive on suspended license like all the time. So it doesn't necessarily create a situation where they do pay all the time. Now, if you suspend like a business, professional license, something like that, okay, that could definitely affect them. And there's also like liens on property, seizures of assets, and then of course, like we talked about, the jail time. But and there are different ways as the attorney to talk about, hey, what is available? What do we know exists? How can we be creative in at least asking the judge, hey, look at this for us?
Is there one way that has proven to be more effective than another?
Well, garnishing wages is by far the best because it just happens without their control. And one thing that does work well, and so for anybody listening, think about this. If once you get an order, and there are some procedural things with how you do it with the state of Florida, but then they'll nab their tax refund if in fact they're working and they have one. So that gets people's attention.
Okay, because they think, oh, yes, I put in all my banking information. I'm going to have this in a couple of weeks and I'm going to have my money. And all of a sudden, they don't get it.
Yeah. And now here's something that really gets people fired up. I know you're going to like this. Okay. So your ex, not paying, not doing what he's supposed to, you get this order, and then now you can garnish the wages, but also the tax return. They're remarried and they filed jointly. So guess what? It's not just his refund, it's all the refund. So then you really tend to see some action once their new spouse is affected.
Oh, I do like that. Okay, let's talk.
Uh-huh.
So, but wait, okay, well, that goes back to once you get married, there are certain things that are joint that that's automatic.
Yeah, and I mean, it's nobody's going to give it back, as far as like, that new spouse saying, "Oh, wait a minute, that was all mine, but you filed jointly, you should have been aware." You tend to see compliance after that, because that new spouse, like, why am I getting dragged into this? You need to do what you need to do.
Okay, wait a minute. But what if, okay, they're married. What if they don't file joint? I mean, can you still seize the other persons because they are married? I mean,
No, no, no. That would be a way around it. So you might only get one bite at that apple, and then and then that next year when they file may not be doing it. So you want to recognize that for sure.
okay, all righty. Well, we just helped someone out just now, you know? This
Yes.
works in all different ways, I tell you. So let's say that uh, the person has violated the parenting plan. But what exactly does that mean if I've violated the parenting plan?
Okay, so that can be so many things. So like just ignoring time sharing days, and just not showing up to pick up the children, but also maybe not returning them on time. They might say, "Oh, well, I wanted them to stay an extra day." So that's like kind of keeping you from seeing your child. Timeliness tends to always be an issue, but again, that in and of itself, just one thing, is just probably not going to be enough unless it's really impacting things. Um, what you'll see, or what I've seen the most common and reasons why there's going to be contempt in regards to the parenting plan, is that the one parent has a substance abuse or alcohol problem, and that in and of itself is putting the child in an unsafe environment, and or you've got some unsavory people around the child, or people that you're not comfortable around your children. Those are going to be real issues that, again, aren't fixed by money, but you got to get in front of the judge and have some safety measures put into place. And also, like, if there's any kind of alienation, trying to turn the child against the parent, and again, these are all going to be extremely fact-based cases. So you're going to have to really have a good handle on the information, really specificity as to everything that's been going on.
All right, so let's kind of break this down because part of what you talked about has to do with time. But you can't, I mean, you file this contempt order. You can't make someone spend time with someone that they don't want to spend time with. I mean, it's unfortunate. So how does that work?
So, yeah, and that is rough. I mean, that's hard. Many, parents, it's like, yes, of course, I love being with my children, but I never get a break. They don't do what they are supposed to be doing. And the only thing that any lawyers can do is say, well, we can adjust the child support if he's not exercising time, because child support is very much related to how many overnights a parent spends with the child. So if they aren't exercising time, that's really all we can do. We can't force them to see their child or be a good parent, but we can, work to have them pay what they should. So that tends to be something, we do look at. And then, well, let's just modify that because you're, trying to, what I've seen in those kind of situations is, it's like, well, I'm always scheduling around and I'm really trying because, of course, my children want their dad to want to see them and be with them. But they never, they're just not doing it. I would rather modify the parenting plan so I just don't have to worry about trying to coordinate with him. And that, it depends. Sometimes with extreme circumstances that can happen.
But it ends up, if the parent has a change of heart, it ends up hurting the child in that situation, it seems.
It's a hard case no matter what. I mean, those are difficult facts. And usually you're not going to see a change in an individual, certainly based on court action as far as being involved with their child. That's you just either are or you aren't.
That's sad.
It's true though. Yeah.
Yeah. So tell me this, does money possibly make them have a change of heart where they try a little bit? And if so, do they succeed?
Sometimes it can, they'll realize, hey, I'm going to have to pay more if I don't spend time with my kids. So I'm going to try to do it, but usually they can't keep that up for long. I mean, that's parenting is certainly not for the faint of heart and it takes a lot of time, dedication. And if, you don't have it in you to do it, I don't think you can maintain that for very long, no matter how much money is at stake.
And it's possible that they may say, well, you know what, I'm going to hire someone now, I don't know.
Maybe, yeah.
Yeah. Mm. Now, another thing you mentioned when you went down the list of how someone could violate the parenting plan and be in contempt is if the parent has a substance abuse or alcohol problem. That's where supervised visits could come into play, right?
It could. There's a lot that can happen with that depending on the severity of the issue. And, if you find out, generally it's probably gotten to be pretty bad because you're not living in the house with that person anymore, right? So you are only know about this through a third party, which could be your children, absolutely, depending on their age. Kids are smart, they see stuff and they know what's going on. Or it could be that they've been arrested. There are, neighbors tell you. There's a lot of ways, but usually you find out through a third party. So now you've got to see, hey, do I know enough? Can we put enough before the judge so that they take action? And that can be, that again is fact intensive. What do you know? Who told you? Can I talk to these people? Because going in front of the court on that kind of issue is very beyond important. It is in your child's safety, and the judges are going to take that very seriously. But you really have to determine what evidence do I have. I don't, rarely, if ever, do I suggest, we're asking children to testify in these kinds of things unless it's quite severe. So that's where, we really have to look at what are our options on the evidence. But there are a lot of remedies with that. There is definitely supervised visitation. Sometimes the judges will say, hey, you can't have any, or you can only have supervised until you complete a drug and alcohol program and then come back and show us that you did. There's an app, several programs now, like electronically, that specifically for alcohol, where you have to blow in it a certain amount of times during your time sharing with your children. So, there's a broad range of remedies for that. And that's why I said that's one that commonly, we do go on because one, the child's safety is of a concern. And there are clear remedies that the court can impose in those situations to really give you relief and protect the children.
One thing you mentioned is not having the child testify. Do you try to keep children out of the court or and out of this situation as much as possible, dealing with family law and divorce? Try to keep them away from the courtroom.
Yes, and the rules are very specific. You have to clearly get court permission in way in advance before you bring that situation, the child there. And there can very well be times, depending on the age and maturity of a child and the issues that are going on. But the better remedy would be to have a guardian ad litem who can then speak on behalf of the child. Because, children that no matter, it does depend on the situation, but for them to have to speak badly against one parent or the other puts them in a difficult position. And that's not really ideal at all.
Mm, no. Talk about some of the things that you can look back on life and say that that was one thing that affected you the most, as a if that happens to a child, right?
Yes, I would think so. I mean, some judges, and that's where, one parent's like, yes, they should testify, the other not. It's kind of like, wow, nobody, is it that important that happens? It's hard to say.
You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. When we return, we're going to talk more about enforcement, divisional decree violations. Stay with us. Welcome back to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. Enforcement orders. All right, Heather, 3 words that are put together, and I'm thinking, why are they together? Divisional decree violations. And I'm like, I looked at this and I said, whoa, okay, I got to say that slowly. All righty, what is a divisional decree violation?
So that's when there's a property or an asset that was supposed to be divided as part of the divorce, post-divorce, whatever. And so now you're looking to have that enforced, and you've got to go to court to do that. But it can't be contempt for those types of things. So it has to be under enforcement.
All right. Does I looked at you. Now you defined contempt order, enforcement order. You defined it in the first part of the show. If you guys missed any part of this show, please go to our website, womenwinningdivorce.com, and download, subscribe, and listen. Now you broke it down, enforcement order, contempt order, but it's still a little, fuzzy for me, because I look at this and I'm thinking, well, property is money ultimately. You know what I mean? Does that make sense?
It absolutely makes sense. And that's where it's, it gets into all the legalese and what legally your remedies are. And again, this is something that you do the divorce yourself. You didn't have the correct language. You didn't have something that allowed you to enforce these things that you agreed upon and these divisions. And now you are going in under enforcement. Sometimes you have to file a completely different lawsuit if it was really, messed up. But basically you're saying, hey, this order states, my ex has to do A, B, C, D. And he's only done A, and I'm sitting here waiting on the rest. And there's no, good reason, judge, order him to do that, within a period of time. Because again, that's the thing. If you don't have a time period, that can make it a little bit more challenging. So, when we talk about a lot of this enforcement and contempt, I'm certain people are listening thinking, yeah, I tried that. It didn't work because the original divorce, the original court order wasn't specific enough and didn't really give me the teeth, to go in and enforce it in the way that you'd want. But these are, things that you're trying to enforce, like they failed to pay an agreed upon debt. Now, then you go and get an order at enforcement. Then after that time, you might, be able to follow up as contempt, but it just, again, it draws it out. But at least you have enforcement, like I said, again, the home, they're not selling it, they're not leaving it, helping you, move, they had to move property out and they had a certain amount of time, or they haven't transferred over, say, retirement accounts.
Okay. Now, what about animals? I thought about that. That's a property.
Yes, yes. So they don't turn over the pet. And now I will tell you that we had this issue in our office with one of our attorneys, and it got almost to the point. Well, I think the judge gave him one more pass and said, "Are you seriously not returning this dog? And am I going to have to make a decision on this?" And he returned the dog. So, but yes, yeah. I mean, people do things that you do not expect in these situations.
All right. So this, I hope this, hopefully this isn't off topic, but when I think about things like returning a pet, I think, is there something deeper there? You know what I mean? Something deeper that they're connecting with the pet in the reason why they don't want to adhere to this arrangement.
Well, yeah, I mean, that certainly is it. And there's also that aspect of it that if that's hurting you, that's making them feel better as well. So can't discount that. Yes, there's a connection there, but it's usually not just that. There is some aspect of you want this, and this is now maybe the only like control I have over this situation. So this is why I'm doing this. If
Okay.
that makes sense.
Yeah, it does. What if my name is on a deed to a house or, titles for a car or anything like that? Would that fall under enforcement?
Yes, it would. And the court can order specific language to retitle property. And again, that if done correctly, that can be done. But yes, that would be something. They haven't refinanced something, you're still on a mortgage that they were supposed to do. That can happen a lot.
Actually, you know what? I'm glad you said that because this kind of goes back to something we were talking about earlier, and you know what? We're going to get into a little bit of that. So I want to ask you something else. All right, so tell me this: if found in violation of any of the things that we've talked about, what could happen to you?
So there are, the judge could force the sale. And sometimes, when people sue each other outside of divorce in civil court, they get a judgment. That's what they get that says, hey, this person owes you X amount of dollars. Now, then you have to go collect on that judgment. So you can get a judgment by which then you have to go collect on it, which could be through property they have and having that to be sold in order to satisfy the judgment. Sometimes it can't really be on their homestead where they live because that's protected, but sometimes there can be other property they own. Yes, there can be wage garnishment, and that is also an option. And sometimes, they can order that your retirement funds are going to be dispersed to the other person, and that's getting a specific order as to someone else's retirement, which is we call quadro, which is just the acronym QDRO. So those are lots of different things they can order. That home has to be sold, and so then that would be a common one on a home and mortgage, not refinancing.
Okay, but I thought you said that they can't do anything with the homestead.
Well, but both of you are on the name. So in
Uh,
divorce court, yes, we can order your house to be sold. If you got a judgment, say for $20,000 against him, you can't really file a lien against someone's house. From a homestead, from a creditor, the bank can, the IRS can, but like just your regular debt holder, they're not going to get paid out of that, if
okay.
that makes sense.
Yeah, because it would put them in uh, a bind even more, and you definitely probably won't get the money then.
Correct.
Okay, all righty, that makes sense. Something else that I wanted to ask you about that I thought about after the fact that came from segment 2 under property liens. Is it possible that someone doesn't even realize that they have a property lien until they may go to sell it? And then they realize, oh, okay, there was a property lien on that, and I can't do anything with this until I make sure that I pay whatever I need to pay.
Correct. Very often, yes, they don't know that.
That's sneaky.
Mm-hmm.
Hmm. And I wonder how often that's used and how successful it is. Because if it's a property that you were not thinking about it at all, and then all of a sudden, you go to sell it, and then you realize, oops, can't do that.
Correct. Yeah. They go through that whole process, just like anyone who's ever sold a house. And, it seems as though there's all these things that arise at 5 p.m. the day before you're supposed to close. And they're like, oh, we're trying to look at this and that, because they're searching the title. So similarly, if there's something else, if it's something where you could attach a lien that would be then searched, yes, that impedes somebody's ability to sell it and move forward. So then obviously they're motivated to pay it off.
Okay. All righty. That's what I wanted to ask you. So talk to me in general about contentment. All right. Contempt and enforcement motions are like the divorce process. How long does it take? Could it be a long time?
Well, yes. I mean, just like anything, indeed, because there are legitimate ways that things get pushed out. Meaning, like I said, I talked about in the beginning, the proper service for things that they've been notified, and that um, you know, many times they are given a period of time with which to comply. So that could be an issue that could delay it. Um, and or just trying to maybe not having everything ready at once. Say you're trying to go do this on your own and you don't really have all the information. So yeah, it's not as long as the original divorce process, unless for some reason they file something that then gets you put into the whole mediation and all that in a different way. If it's straight contempt or enforcement, I mean, you should be in and out of there in 3 to 6 months.
Oh, well, no, no, no. To me, that's a long time.
Well, I know it is, Julie, but really that is pretty reasonable.
Oh my. Okay. All right. Wait a minute. Okay. And then I think about it's going to cost a lot too.
Well, I mean, yeah, if you want relief, you have to pay for your fees. So, and yeah, it does.
But if I am granted what I'm asking for, my ex-spouse will have to pay it, right?
Well, that's ideal. And yes, I mean, most of the courts, if you have to go to this length to make somebody comply with something they've already been told to do or agreed to do, yes, your chances of getting reimbursed for your attorney's fees are fairly good. Not guaranteed though, so that may be something that, you know, hate to have that prohibit somebody from moving forward, but you need to be prepared to pay your attorney's fees. It is always the goal at our office to get your fees reimbursed from the other person, without a doubt. But that then depends on the judge and how egregious their behavior was.
Oh boy. All right. So ultimately, it would be better if my ex-spouse and we had a better relationship and none of this really happens.
Well, yeah, I mean, that would be ideal, but it's not always possible. But yeah, when these things are happening, you want to reach out and prior to going to court saying, hey, you're supposed to do this, and be very specific. Ideally, put that in writing that this is what they haven't done. I would like you to get this done within, a reasonable amount of time, and being specific and trying to communicate without court.
Yeah, I know. What I said was a perfect world, and we definitely do not live in a perfect world.
No, and it's always worth um asking. It really is, because then you look better in the court's eyes.
Ah, I like that. All right. Anything else you want to add?
Just that, we've talked about a lot only on the surface, and not everything as is always as it seems. But if you are in a situation where you're, you know, wanting to enforce an order, believe that your ex is in contempt, please reach out to us at Florida Women's Law Group, because we're certainly here to help you and can at the very least let you understand what remedies you have available.
Well said. Until next time, Heather.
Yes, indeed. Until next time, I appreciate you so much, Julie.
Oh, I appreciate you too. Thank you for listening to Women Winning Divorce. We hope you found information to help you navigate your divorce. If you like our show, please take the time to subscribe and provide a 5-star review. If you need more information, please visit our website at womenwinningdivorce.com, where you will find previous episodes and other helpful content. Join us next week as we continue our journey of women winning divorce.
Wake up! It's time to stop dreaming about new floors and start heading to LL Flooring's Dream Floor event. It's the biggest sale of the year on floors that are in style, in stock, and in your budget. With up to 25% off more than 300 styles, there's never been a better time to get new floors.